Lord, this is, my Lord, the copy is given.
Leave yourself a little time to deal with the challenges to the amendments to the statutes. Huh?
These are, my Lord, the objects.
Right, right. We have now covered the scheme.
No,
I'm just saying that since you have an hour to conclude, give yourself a little time to deal with the challenge to the statutory amendments.
that's what, my Lord, my answer is, one line answer. The statutory amendments are to ensure that this scheme can be framed and can be operated. That's the purpose of the amendment. There are no separate objects.
That's okay. And you have really covered the reasonableness aspect as well.
There are corollary.
Yes.
To, my Lord, the scheme. First, it came under the Reserve Bank of India Act that government can formulate the scheme. That is challenge to the Reserve Bank of India Act. My Lord, now by itself is not illegal.
Just wanted to ask you this. It may not be very relevant but just to understand the legal framework. Why was it necessary to amend the RBI Act actually to bring in the scheme? I mean, as a matter of law, what was the reason?
Lord,
we just have that. I have, in fact, it opened here at page 31 in your written submissions. Section 31 says that no person except the Reserve Bank of India or the central government can issue a bill of exchange, promissory note, or engagement for the payment of money payable to bearer on demand.
Well, it would be a bearer bond, my Lord, because
the reason seems to be, and that's RBI's report, that only central government and RBI is permitted under that section. The issuance is being done by SBI now.
So no. That's not the idea.
Yes, so it's somebody else which is being permitted, and that's one of the reasons which the RBI's letter also, which I think Mr. Bhushan showed to you.
Lord, there is nothing turns on the, and you will not succeed or lose on this. But, my Lord, the purpose was
31 may have 31.
Please see, my Lord, 1. This was to make an exception to 1.
That there's an authority or the legal
there
power.
There is a statutory backing to the scheme.
That's what to be confronted with the legal
that
challenge.
Is a purely executive act.
Yes, otherwise it would have been challenged as an executive act. Backing. It could have been said that it's a bearer bond, only the RBI can issue, etc., etc. And therefore, my Lord, with a view to empower the central government to come out with this policy.
And it would otherwise fall within the broad definition of a bill of exchange.
Exactly. Or a bearer, my Lord, instrument. They say payment of money payable to bearer on demand to borrow.
Or engagement for the payment of money payable to bearer on demand. Engagement is very broad.
And one,
therefore that
Lord, subsection 1, first line.
Yes.
First line, subsection 1. No person in India other than the bank, that is RBI, or as expressly authorized by this act. So this is the authority given to the central government. That's all. But to give a statutory backing so that it doesn't remain an administrative instrument.
All right. Now what next, Mr. Solicitor?
Yes. It doesn't contain the name of the donor. My Lord, I can purchase it from Assam, Guwahati, because that is one of the SBI branches, and pay in Delhi to Indian National Congress or Bharatiya Janata Party because their office is situated here. They can have their authorized account practically, generally in Delhi, but anywhere in the country. And I can purchase it from Delhi and pay to Trinamool Congress in Calcutta. They would have their account in Calcutta. Now 4, separate storage and separate collection of data ensures that there are no direct linkages maintained in the database between the donor details with donee details. 5. The register which is maintained at the designated branch, please mark this, which issues the bond does not maintain the register with names of the purchaser or the donor. So if I go and buy a bond worth 1 crore, the register would only say one bond issued, 1 crore rupees. My name will not come. The only person, my Lord, I must, my Lord, tell your Lordships, which would temporarily come to know would be the cashier, my Lord, when I go with my KYC documents. Because
the issuing bank.
Yes, one person.
11.1 says, all payments for the issuance of the bond shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit to the buyer's account.
Yes. So it will have to be through banking channel. No, the purpose is this.
Bank, and therefore the issuing bank has all the data.
No. It would come, Lord. Therefore, it would come. The only person who would first know My name and is the person to whom I give KYC. Then KYC is sealed cover is maintained elsewhere. Well, it comes. The details of donor, i.e. the KYC details are put in a sealed at the end of each tranche, because within 15 days, many people purchases many multiple bonds. But I may purchase 10 bonds worth 10 lakhs of rupees. Tranches by the designated branch and sent in a sealed covered from form to the SBI main branch, Mumbai main branch, where it remains sealed till the contingency under clause 7(4) arises. So Guwahati, where purchases are made, or Trivandrum, where purchases are made, will send it in a sealed form to Bombay. So far as the redemption of these bonds by the political parties is concerned, each party can deposit such bond only in their designated account. In account details of the political party also, only the amount of the bond will be reflected, as the bond does not contain the name of either purchaser, donor, or the political party. The political parties would have one designated account in one branch out of the designated branches of SBI, in which only the redemption of electoral bond is permissible. So bond may have been purchased, my lord, from Chennai, but will be redeemed or can be redeemed in Calcutta. However, the political party can present the bond for redemption in any of the designated branches, which will credit the amount only in the main designated branch. They can go to Jaipur and say that this is my bond. The money would be transferred without anybody's name to the designated account wherever it is maintained, one designated account. At the time of redemption, the original bond, the pay-in slip would be storage in a sealed cover and sent to SBI Mumbai main branch. Both the sealed covers cannot be opened either together or at different times, except under the contingency under clause 7(4) arises. In the event of contingency under clause 7(4) arising, it would be very difficult to trace out that. Even after that, my lord, kindly see this. It's not as if we open the cover and match it. Trace out the details of the purchaser of the bond, as such purchaser may have purchased several bonds from several designated branches in different tranches. In other words, several sealed covers may have to be opened and examined. 2. So far as details of redemption details are concerned, they are stored in the Global Information Technology Center of SBI, which stores the data in a digital format. In case the link between the donee and the donor is required to be established in terms of clause 7(4), it would require a detailed and in-depth tracing out of information from two different information silos of donors and donees. The said exercise is not automated and cannot be carried out in a linear fashion and requires a scanning of different databases which are designed without maintaining interlinkages. Therefore, the process of issuance and redemption of electoral bond and data generated therewith is not maintained in a central database, and the data sheets are not populated and tallied at one end. There exist no direct linkages, and completely separate information silos are stored under separate heads with separate departments. So I'll have to ask several people to collude with me if I want to get the information. Because, Lord, I have not given that, but this center, Lord, Global Information Technology Center also, as I was, Lord, explained, I was also not explained in detail, and nor did I insist. But they also have 3-4 layers. It goes, the request with the court order goes to one, he will open, then it goes at a second layer, then he opens, and everything is digitized, leaving the footprints. And therefore, my lord, to satisfy your lordship's conscience, I say that please criminalize if there is anybody who breaches this system.
Yes.
Yes. Now, Lord, I'll come to, my lord. Please come to page 36 of my written submissions. Rather, my lord, I would, my lord, at page 37, My lord, I have quoted Puttuswamy. And my lord, I'll abide by the time, my lord, your lordships have indicated. But your lordships would, my lord, bear with me. I have not repeated, my lord, except
No, not at all.
I have. My lord, I'm not reading this Puttuswamy, my lord, your lordships, all of my lords have read and
Yes.
reread. But the purpose, I'll say, Lord, your lordships have devised this concept of informational privacy. Lord, your lordships were examining two competing interests, namely, one, right to know, and second, right to have informational privacy. And your lordships have accepted information privacy to be a fundamental right. If, my lord, I am the person donating, and if your lordship's conscience is satisfied that system is in public interest, your lordships can, Lord, accept my right to informational privacy as against general right to know. And why, my lord, I say this? If there is a genuine public interest in the disclosure, you go to the court, you have 7 for remedy. But merely for your curiosity, you cannot invade somebody's privacy if that privacy ultimately serves larger public interests. My lord, that's the submission which I have made. My lord, I have quoted the relevant paragraph. I am not, my lord, reading it. Your lordships are aware. In the matter of Puttuswamy, this honorable Justice Puttuswamy, this honorable court discussed the validity of Section 33 of the Aadhaar Act, which provided for disclosure of information including identity. I'm sorry. Lord, I was on 95 reading Puttuswamy, second para, 95 second para. It is submitted that while upholding Section 33, this honorable court, however, added a layer of safeguard as per which such information may be shared only upon an order being passed by the judge of a high court. Now, your lordships respected the privacy, but in public interest, if lordship says that if it is required, then of course with the order of the high court.